The first question that I come across that I look at when I'm dealing with estates is titling. How is the property owned? There are a couple of different uh, uh, formulations. So you can have a married couple, which would be a tenancy by the entirety, joint tenants with right of survivorship, where the surviving joint tenant will automatically inherit the property if one of the joint tenants predeceases, and tenants in common, where each owner of the property owns a separate share of the property. Could be 50-50, depending on how many people you have. It could be different percentages. But that's really what you have to look at first in terms of, do I need to do an estate proceeding because somebody died? Again, oftentimes I'll have a married couple, one of the spouses will predecease and the survivor will say, well, what do I need to do anything? And the answer is no, you were married at the time. The property automatically comes to you. The deed says either husband and wife or a married couple. In the case of co-ops, that will be right on the stock certificate. So that's really the first inquiry, is how the property is owned. If you have one individual owning the property or the surviving spouse owning the property and the person dies, then we have to talk about probate, estate. Is there a will?
So let's chat quickly about just the three different types of ownership, right? So we have joint tenants, which, if my understanding is, you can correct me, if somebody passes away, their interest automatically passes over to the other person.
Joint tenants with rights of survivorship,
right? Then we have tenants in common. A little different, right?
A little different, exactly. So in that case, if you have, more than one, you have two or three persons and they are tenants in common. Actually, the presumption is, if these owners are not married, the presumption is that it's a tenancy in common. Sometimes the deed won't specify. So you really have to look at the deed for how that property is titled. But if one of these tenants in common dies, then you have to have some type of probate proceeding in order to pass his or her interest in the property. It could be a 1/2 interest, a 1/3 interest. Whatever the case may be.
So tenants in common, sorry to interrupt, is nothing automatic. Right.
Right. There's no automatic survivorship or passing of the title. You've got to.
The third piece to the puzzle is tenancy by the entirety for husband and wife.
That's right. And that operates very similar to a joint tenancy with rights of survivorship. There are some subtle differences. You have some protections as a married couple. But for our purposes, it's basically the same as a joint tenancy with right of survivorship.
And just drilling down, and then we can move on from this. So on the deed, there's certain language on the deed or on a co-op stock certificate that's needed to prove whether or not joint tenancy applies here. So if it's John Smith and Sally Jones on a deed as joint tenancy with the rights of survivorship, John passes away, it automatically transfers to Sally.
But correct.
If it's John and Sally as tenancy in common and John passes away, then you have to look to John's will and have a probate proceeding.
Exactly. And then one, additional clarification: if you have John Smith and Sally, forget what name you, but if they are married at the time that they acquired the property, the presumption is that it's a tenancy by the entirety, and you have that survivorship feature.
Now, last question on this point. What about husband and wife? So that if they own it as husband and wife, is that sufficient?
That's a tenancy. Yes, that's a tenancy by the entirety. Exactly. So the surviving spouse will automatically inherit.
So here's the big question. Right? Agents will come. So and so passed away. What do I do?
Yes. So in that case, so and so passes away. The inquiry is, did that person have a will? And the answer is typically, did that person have an attorney? When we do wills for our clients, we will typically hold the original documents. There's only one original will. So if you have a copy of it, that is probably not sufficient. So sometimes it's a little bit of detective work. Where's the will? Did the person have an attorney? Did they ever do any estate planning? So that's really what we need to find out. And then going from there, depending on whether the answer is yes or no, if they had a will, then we have to find out who the executor named in the will. The will typically spell out who the beneficiaries are, who the executor, could be more than one person. If it's a married couple, it's usually going to be the surviving spouse, but not necessarily. If it's somebody that's passed and they have adult children, again, a lot of times it'll be one or more of the children that would be the executor. But it, not necessarily. It could be a friend, it could be a sibling. So that's what we need to find out, because that is the person that will ultimately, once the will is probated, then that's the person that's going to have the authority to sell the property. That's who you're going to have sign the listing agreement, and that's who can make the decisions related to the sale.
So what documentation would be needed to prove that somebody's an executor? Is the will enough?
The will is not enough. So let's say you find the will, great, it's an original will, it sort of meets all of the requirements. Sometimes we have clients that will, they're do-it-yourselfers, and sometimes they get it right, but usually they're, the requirements are technical. You need 2 witnesses to have signed the will. We usually do what's called a self-proving affidavit with the will. And then again, we need to find the original will. Hopefully it hasn't been pulled apart to copy, because then you need to explain to the court why the will isn't stapled together. But once you have the will, then it needs to be submitted to the surrogate's court in the county where the decedent resided when he or she died. So if you've got somebody that lived in Garden City, then we're going to Nassau County Surrogate's Court to submit the will and prove it. If they resided in Manhattan, it's New York County Surrogate's Court. The surrogate's courts are specialized courts that just deal with estates, decedents' estates, and they usually run pretty well. People hear horror stories about probate, but sometimes it can be not such a horror story. So the will has to be submitted. We will typically have the executor sign a petition. The heirs, whoever the people are that would inherit the property, if there were no will, they all have to be notified. So if you have a spouse and children, those are your heirs. They have to get a copy of the will and they have to sign off on it. Usually no problem. Usually they're the beneficiaries, but not always. You don't necessarily have to leave your property to your spouse or your children. So, that's where things can get a little tricky, but those are the people that have to sign off on the will. More times than not, everybody does. They sign what's called a waiver and consent. The will is submitted to the court, and then we'll have letters testamentary, which is the official approval of the court of the will and appointing the executor to take any actions on behalf of the estate.